make a mention, Lordship, land acquisition matter, fresh submission kind.
The Honorable Court directed to list the matter on 2nd December. We commencing from 2nd December 2022. Thereafter, I mentioned 2 times it has not been listed. So my respectful prayer to list the matter as because the petitioner is residing outside of the, in spite of payment of the full payment, is residing outside, and the document has not been released. Kindly on the matter to.
Orissa government land settlement matter.
Well, appeal, my lord, I filed for bail. Life conviction is there, more than 8 years in court. Another matter, repetition matter, is directed to list it after service of notice. The meantime, notice is
Sure. I beg pardon to mention, my lord, item 14. My lord, that day, my lord was rightly suggested that we should approach to the OPDR Act. And I am permittedly withdraw to approach. Liberty may be given. Filing a memo. देखिए मेमो टा से अप्रोच करछन सब लेटर किंतु जो प्रोसेस रे करिया कथा करना आइटम 14 में ओब्लाइज तो पूरी बात को करो Yeah, the memo is taken on record. The writ petition is disposed of giving liberty to the petitioner to approach the appropriate authority. Yes, oblige.
For judgment, item number 1, W134 of 2017.
The Honorable Single Judge in the impugned judgment has rightly observed that the appellant's case had been adequately addressed in prior proceedings, including OJC number 13411 of 2099 and 1999 and WPC number 12199 of 2008, where partial relief was granted. The directions in those cases led to her formal appointment on 17/6/2005, conclusively resolving her claims to the post of assistant professor through lawful and transparent procedures. Reopening these issues in the current petition undermines the finality of judicial determinations and the integrity of appointment procedure. The appellant's claim also lack equity. Allowing her retrospective benefit would create an untenable precedent where individuals performing her duties without formal appointment can claim benefits, thereby circumventing established recruitment procedures and statutory safeguards. This would be detrimental to the principle of fairness and equality in public employment. For the reasons above, the impugned judgment in WPC 15499 of 2008 by the learned single judge is upheld. The appellant's claim for retrospective regularization salary and seniority benefits are rejected as legally unsustainable and procedurally flawed.
I agree.
Supplemental list, item number 2.
Please, Your Lordship.
I think this matter is in process, Your Lordship, because Your Lordship disposed of 30044, the same petitioner.
You are for the petitioner.
Yes, madam.
My friend is the respondent. I am the petitioner, Lordship.
Lordship, kindly come to page 8 of the
No, just a
first
minute.
order.
Why are you making a submission that it has become infructuous?
Yes, my lord, because 42331 petitions
but-
listed, that is filed in 2023. After that, we issued press possession notice, and he challenged that possession notice.
So what is challenged here?
Dear Lordships, while this writ petition, Lordship, kindly come to page 8 of the order passed by this Honorable Court. Operative person is Lordship at page 9, para 5.
Kono?
Page 8 of the order passed by this Honorable Court in WPC number 31980 of 2023. Operative person is Lordship at para 5, page 9. Considering the facts and submission, the petitioner is direct to approach the opposite party bank for regularization of the NPA account and the payment of overdue amount, and the opposite party bank shall consider the same in accordance with the law. Thereafter, Lordships, page 12, the bank wrote a letter to me. I filed a application before the bank. Bank wrote a letter, page 12. Operative person, Lordship, para 4, page 13. May I read, Lordship?
Yes.
That as per the direction of Honorable High Court, it is to your kind notice that you have to pay 2,10,000 amount for regularization of the NPA housing loan account, and to go on paying the EMI regularly. It is also to your kind information that the housing loan account is not coming under any OTS scheme of the bank, for which the same cannot be settled under OTS. However, if you want to close the loan account, then you have to pay the total outstanding of 17 lakh as on by 31/10/2023. Lordship, then Lordship, kindly come to page 11. Page 11, Lordships, on 1912, 2023, Lordship, I paid 2,50,000 pursue on to the direction by this Honorable Court and the letter asked by my bank, Lordship. Now they have to restructure it, reschedule it. Meantime, what they have did, they filed an auction notice and possession notice, Lordship. During this pendency, I filed another writ petition, which your Lordship says, since it is 13B notice, you have to go to tribunal. Lordship, this fact, Lordship, could not be brought my Lord's notice, because on the date I said, my lord, I had filed another writ petition, let it be tagged before this Honorable Court. Since it came single manner, I could not bring this notice. Lordship, I have complied this Honorable Court order.
No, this Honorable order was simply just you approach.
Yes, sir.
Lordship,
Just a minute. You just now read the operative part of the order of this court
Lordship,
in WPC number 31980/23.
Lordship.
So there, the direction was that you are to approach the opposite party bank for regularization of your
Lordship.
NPA account and payment of the overdue. Accordingly, you sent the legal notice and they replied you.
Lordship.
That letter also you placed. That letter is dated 7/11/2023.
7/11/2023.
23, annexure 3.
Lordship.
And the portion which you are pressing, that is annexed page paragraph 4 and 5.
Lordship.
Right.
Lordship.
So what it has been stated that you have to pay rupees 2,10,000. This is for regularization of the NPA account and to go on paying the EMI regularly. Okay.
Lordship.
And they further stated that this is not coming under the OTS scheme of the bank, for which the same cannot be settled under the OTS. So, and if you want to close this much of amount,
Lordship.
so thereafter you stated that you just deposited Rupees 2,50,000.
50,000 on 9/12/23.
All right, 9/12/23.
23. Because this is their statutory notice within 60 days I have to pay. I paid before 30 days. They asked for 2,10,000, I paid
All right,
2,50,000.
it's all right. Now that is done in 23.
Last
When this notice was issued?
7/11/23.
No, this 13/4 again they have stated that
Thereafter.
notice you have stated.
That notice they have issued, Lordship, 14/11/24.
14/11/24. So almost a year after it has been. And that is also the subject matter of another writ petition.
Yes.
So how this, he has rightly stated now, this writ petition has become infructuous. You can take all those grounds there also. You must have taken also those grounds. Since a phrase cause of action arose, and you have also not strictly complied with their direction, or that you are to not only pay, but you are to pay the regular EMI. Are you paying that? You are not paying. As per that later annexure 3, it is not just 2,10,000. You are to go on paying the that is very clearly go on paying the EMI regularly, and that cannot be settled under the OTS. And if you want to clear it, 17,50,000. Admittedly, you have not paid 17,50,000. No, just we want to know. Have you paid 17,50,000? No.
No.
Have you paid EMI? No.
EMI, Lordship, when they asked me for 2,10,000, thereafter they took 60,000 extra. I paid 2,40,000. Thereafter 20,000. They say, Lordship, kind.
এই ডেটରେ ଯୋଉ ଇସ୍ୟୁ କଲେ 14/11/2014 ଆପଣ ଯଦି EMI ଦେଇଥାନ୍ତେ
ସେମାନେ ରିଷ୍ଟ୍ରକ୍ଚର କଲେନି, ପୁଣି 20,000 ମାଗିଲେ, ମୁଁ ଦେଲି.
that you raised.
Minor, the balance is more than 17 lakhs.
They have to restructure. I
applied interest.
They did not restructure it. I was willing to pay.
Petition has been filed for a direction to the opposite party UCO Bank to consider the case of the petitioner in granting the benefit of the OTS scheme. With a further direction to declare the letter dated 7/10/2023 issued under section 13(2) of the Surface High Act as not binding against the petitioner. It appears that the petitioner earlier approached this court in WPC number 31980 of 2023, challenging the inaction of the bank authorities over the grievances of the petitioner for full and final settlement of the outstanding loan dues with easy installments, one-time settlement scheme, or in any other scheme provisions. This court by order dated 18/10/2023 disposed of the writ petition, giving liberty to the petitioner to approach the opposite party bank for regularization of the NPA account and payment of overdues amount, and the opposite party public bank was to consider the same in accordance with law. It is the submission of the Land Council for the petitioner that after the aforesaid order was passed by this court, the petitioner sent legal notice dated 2/1/2023 to intimate him the outstanding dues for regularization of the NPA account and payment of overdue amount, or for closure of the housing loan account number so and so mentioned in Annexure 3. After receipt of such legal notice, this legal notice was sent to when?
No, 7/11, 2/11/23 by me, 7/11/23 by bank.
अच्छा अच्छा लीगल नोटिस देखे लो 2/11/23 इलेक्शन को अच्छा लीगल नोटिस डेटेड द पिटिशनर सेंट लीगल नोटिस लिख लो 2/11/2023 है ना टू इंटीमेट द आउटस्टैंडिंग सॉन सो बाकी सब पूरे हो खाली लीगल नोटिस डेट after receipt of this one so the bank replied to the legal notice and wherein it is mentioned as follows quote paragraph 4 and 5. It is the contention of the land council for the petitioner that the petitioner has deposited a sum of rupees 2,50,000 on 9/12
19/12/23.
19/12/2023 with the bank. But in spite of that, the on କେବେ ସେଟା issue ହେଇଛି ଯୋଉଟା କହୁଛନ୍ତି please pass on that.
Letter of possession.
ଯୋଉଟା challenge କରୁଛନ୍ତି ମୁଁ
Second
in spite of that
11/24 এটা কেতে 14/11/24 14/11
14/11
ତାପରେ ଅଛି
always date ଟା ନାହିଁ
ସେଟା notice ତାପରେ
11/12/20
11/12/2023
the bank issued possession notice on 11/12/2023 and the said notice has been challenged before this court in WPC number 30044 of 2024. It is the contention of the land council for the opposite party bank that since a fresh cause of action has already arisen and the same is challenged and the possession notice has been challenged in another writ petition, this writ petition has become infructuous. When I put a pertinent question to the land council for the petitioner as to whether after the deposit of rupees 2,50,000 on 19/12/2023, whether he has the petitioner has paid the EMI regularly as per the intimation given by the bank and whether he has cleared the outstanding dues of rupees 17,50,000 as mentioned in the said letter, the answer was in negative. The Land Council for the opposite party bank submits that as on today, the outstanding dues is rupees against the petitioner is
more than 17 lakhs.
More than 17 lakhs. Stop. After hearing the Land Council for the both the parties, since a fresh cause of action has arisen and 13/4 notice has been issued, which has been challenged by the petitioner before this court.
Disposed of on 10/12/24.
In WPC number 3004 of 2024. It has also been disposed of, which has been disposed of on
10/12/2024.
10/12/2024.
Yes.
10/12/2024. We are not inclined to interfere with the we are not inclined to grant any relief to the petitioner in this petition. The petitioner is at liberty to seek appropriate remedy for the appropriate forum. Yes.
Oblige your lordship.
ନାଟା ଦେଇଦିଅନ୍ତୁ ଆପଣଙ୍କର
Item 3.
May I please, Your Lordship?
Yes.
Lordship, item 2, Lordship, only I pray. Lordship, time may be frame to dispose of my
You are to approach the
tribunal.
DRT, file the OA or essay that is stated. That is essay. You have to remove the defect. Then notice has to be issued. So many things. How can we say from this point of time when you have not at all approached the DRT to dispose of your anticipated application? Yes, next.
My pleasure, Lordship. My lord, in this case, my lord, the petitioner has challenged the order of learned tribunal under Annexure 7 and 8, my lord. That is page number 218.
We had already expressed our opinion in order dated 28/11/24.
That there was a direction to deposit the cost.
My lord, I
Yeah.
have already deposited.
The Learning Council for the Union of India has filed the money receipt showing the deposit of rupees 10,000 in the High Court Bar Association as per the order dated 18/11/2024. The same is taken on record. Now, so now you are ready?
Ma'am.
Yes. Have you served a copy of your writ petition?
My lord, I have already said.
Argue the matter.
My lord, the petition has challenged the order of learned tribunal in Annexure 7 and 8. My lord, under
Annexure 7.
my lord. Page number 218 to 226, my lord.
What was the prayer made by the present opposite party before the Central Administrative Tribunal? You come to the paragraph, page number 2 of the impugned order dated 21/6/2021, page 219. Why are you not using that Vakam? So we are repeatedly asking you, and somebody is there also to help you. Number 219.
My lord. The prayer of the
Adjust
applicant.
for mic, adjust for. Yeah. Please read the prayer, that first paragraph itself. Page number 219. That is Annexure 7. Copy of the order dated 21/6/21.
May I read, my lord?
Yes.
My lord, the applicant by filing this OA has paid for the following reliefs
Yes.
under Section 19 of the Administrative Tribunal Act 1985. Number 1, the order dated 12/9/2018 passed by the respondent number 2 under Annexure A/6 may be modified to the extent that the applicant shall be allowed to draw his salary against the post of Chief Office Superintendent level 7 from 16/4/2014 instead of the order passed by the Honorable Tribunal, that is 8/12/2017, and to direct the respondents to restore the applicant's pay to the post of Chief Office Superintendent with effect from 16/4/2014 with all service and consequential benefits within time framed by the Honorable Tribunal, and to pass such order oblique directions as deemed fit and proper, and to allow the original application.
Okay, now you come to the operative part of the order.
My lord.
For that, you have to read paragraph number 12,
My lord.
which is at page 225.
My lord. If the stand taken by the respondents is accepted, then virtually it will amount to imposition of punishment by the respondent's authorities on the applicant for the purpose of reducing the pay of the applicant from 15/4/2017 to 8/12/2017, although the same order of punishment was quashed. It appears that the respondent's department was inclined and took steps for implementation of order passed by this tribunal in Annex A by 3 in letter and not in spirit. It was not necessary in circumstances of this case for the respondent's department to insist that in the absence of any consequential relief granted to the applicant, he was not entitled to the pay which he was going in his capacity as Chief Office Superintendent with effect from 15/4/2014. The necessity of passing consequential benefit arises maybe in case of giving retrospective promotion, notional promotion, or when the applicant is out of job and is directed to be reinstated by any tribunal or judicial forum. But in this case, there was no necessity of passing any such order for giving consequential benefits, and in the absence of any such consequential relief granted in favor of the applicant, still then the respondent department cannot take the stand that the applicant is not entitled to salary as Chief Office Superintendent with effect from 15/4/2014. Of course, if the applicant has not worked as Chief Office Superintendent with effect from 15/4/2014 to 8/12/2017, then he may not be entitled for any particular allowances like traveling allowances, etc., to which a person is normally entitled if he works in that capacity on day-to-day basis for that period. But claiming pay of Chief Office Superintendent with effect from 15/4/2014 till 8/12/2017 does not at all come under scope and ambit of consequential benefit, and the right and claim of the applicant in the present OA is clearly covered by the earlier order passed by this tribunal via Annex A by 3, and therefore the respondents were duty bound and legally bound to grant pay in favor of applicant which he was entitled to in his capacity as Chief Office Superintendent with effect from 15/4/2014.
So he was working as that as Chief Office Superintendent from 15/4/2014,
My lord.
and in spite of that, you have denied it.
My lord, my lord, his pay scale was restored with effect from 16/4/2014, my lord. And as there was no clear order from the learned tribunal in the earlier OA, my lord, that was not granted to him.
No, it has been released with effect from 16/4/2014.
14, my lord. His pay
Is
was
it
No,
true?
restored.
it was released. It was from
But
8/12/2007.
but payment of from 2014 to 2017 was not made because there was no such.
Ah.
That was the grievance.
Hmm.
And subsequently, in the CP also, my lord, there was no such clear order as regard to the payment from 2014 to 2017.
What was the earlier order? Have you annexed it?
Yes, ma'am.
Where is that?
My lord, annexure 4 series.
Annexure 4 is the original application.
My lord, the operating portion is
No. Which page is the
170.
170.
170.
Oh, that is not the one. That's a 170.
Acha, that is
The punishment order was set aside.
So it is taking a cumulative view of the entire scenario.
My lord.
It is abundantly clear that holding the delinquent employee guilty of consuming liquor has not been proved legally, as the inquiry officer reached to his conclusion basing on preliminary inquiry report, which cannot be taken into record. Hence order, who is allowed inquiry report dated so and so, disciplinary, so everything was passed.
My lord.
And he was during the pendency of the proceeding also, he was discharging his duty as that chief superintendent.
No, he was senior clerk.
My lord, he was continuing as chief office superintendent.
Yes.
The
Even though the proceeding was instituted, that departmental proceeding was instituted, you are continuing
as senior clerk
Oh.
reduced to the lower stage. That reduction order was set aside by this the Honorable Tribunal in this original application. My lord, when they have not challenged that order of this Honorable Tribunal, this order was not assailed by the department. Rather, they implemented this order. While implementing the order,
Partly.
they restored me to the post of chief office superintendent from the date the tribunal passed the order. My contention is that, my lord, once the order of reversion from chief office superintendent to the senior clerk has been set aside by the honorable tribunal, I am entitled for the benefit as chief office superintendent because I was not allowed to continue as chief office superintendent on account of the punishment order. My lord, once the punishment order has been set aside and it has never been challenged by the department in higher forum, while implementing the same, they hold that you are entitled for the actual financial benefit from the as chief office superintendent on 8/12/2017 when the tribunal quashed this order of the punishment. So far as, my lord, that 15/4/2014 to that
8/12/17.
they made it notional as office superintendent because you have not discharged.
Although you were precluded from working in that post because of that order.
My lord, that is the whole case, my lord.
The counter there is a-
This writ petition has been filed by the Union of India challenging the what is that?
That Annexure 7.
Challenging the order dated 21/6/2021 of the London Central Administrative Tribunal Cuttack Bench in OA number 816 of 2019 and order dated 19/10/2023 passed by the tribunal in RA number 260/009 of 2021. Which arises out of the said OA. In OA number 816 of 2019, which was filed by the opposite party Samuel Ika, the prayer was made inter alia to modify the order dated 12/9/2018 passed by the Divisional Railway Manager and Revising Authority, East Coast Railway, Sambalpur, to the extent that he should be allowed to draw his salary against the post of Chief Office Superintendent Level 7 from 16/4/2014 instead of the order passed by the Honorable London Tribunal, that is 8/12/2017, with a further direction to the respondents to restore the applicant's pay to the post of Chief Office Superintendent with effect from 16/4/2014 with all service and consequential benefit. The London Tribunal had order dated 21/6/2021 has been pleased to hold that has been pleased to allow the original application and directed the respondent to grant pay in question to the applicant within 3 months from the date of receipt of the copy of the order. A review petition was filed by the Union of India seeking review of the order dated 21/6/2021 in OA number 816 of 260/816 of 2019, and the London Tribunal did not find any apparent error on the face of record, leading review of the same, and accordingly the review application was dismissed. So the London Council for the Union of India, Mr. Deepak Gochayat and Mr. Parhi Lanen, Deputy Solicitor General, submitted that the petitioner during the period from 16/4/2014 to 8/12/2017 has not discharged his duty as Chief Office Superintendent Level 7. In fact, he was uh, discharging the duty of
Senior clerk.
senior clerk, and therefore the grant of salary to the petitioner for the post of Chief Office Superintendent Level 7 for the said period cannot be sustained in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The opposite party has already entered appearance, and he has also received the copy of the writ petition put up this matter 4 weeks after the counter affidavit be filed. In the meantime, give a date. Yes. Who will it be? Who will it?
Item 4.
Your Lordship. Your Lordship, this is a writ petition filed against a land acquisition of the petitioner. The petitioner is a industry which is located at Sundargarh. Your Lordship may kindly go to page 43, annexure 2.
No, when your land was acquired?
The land was acquired on 21/1/2016, Your Lordship.
21/1/2016. And you have not yet received any compensation?
We have received only part payment towards structure. But the land payment has not been done till date. And after inquiring through RTI, it is found out that there is no award being passed.
So, where is the reply of the in your RTI application?
Yes, page 83. Your Lordship can kindly go to page 83.
So
84, Your Lordship. With reference to the letter of the subject cited above, I am to say that it is found from the award registered of village Mandi Kudar that the plot number 18, 19, 20 are not acquired by government for expansion of State Highway 10 on 2014. And there's another letter also at
86.
86, Your Lordship, similar. So here what has happened is, Your Lordship, the payment that I received, I was supposed to receive 74 lakhs on structure and 100% solicium. That comes to around 1 crore 45. Instead of that, I got only 1 crore 2 lakhs. That deduction has been.
The question is
Yes, Your Lordship.
that if your plot number 18, 19, 20 and 20 by 1
Right.
of village Chungi Mati,
Right, Your Lordship.
Kansa Bahal
Kansbahal.
Sundargarh,
Kansbahal Sundargarh.
Kansbahal Sundargarh,
Right.
that has been acquired for expansion of the
State highway.
state highway, then certainly you are entitled. But
Right.
they say that it has not been acquired.
But Your Lordship, I have been given payment. Then there are letters also that 21/6.
How can we
Yes, Your Lordship.
know that, or how can you substantiate that
Right,
yes,
Your Lordship.
the authorities have in fact acquired that land for the state highway?
Or that the structures were standing over these plots.
Right. Annexure 3, Your Lordship, may kindly go. Page 44.
Not visible.
This is a letter from Tehsildar Rajgangpur, which shows.
Sorry, we just show us about those plot
Yes, Your Lord. Page 46, serial number 12, 13.
46. Just
Yes, Your Lord. 12, 13 and 14.
Please, 46.
Yes, sir.
12, 13.
And 14, Your Lordship.
12, 13 and 14.
So
Yes.
12 reveals the IDCO plot number 19.
Right, Your Lordship.
13 is 20.
Right, Your Lordship.
And 14 is 20 by A.
Yes,
Not
Your Lord.
1.
These are my. Yes, Your Lordship.
So 1920 involves.
Right.
19, 20, 20 by A.
18,
20 by
19
A.
and 20.
But one plot is another
18.
plot. He says
18 is not.
18 is there. Your
18 is there.
Row 11. 11.
11 is there.
So 18, 19, 20 and 20 by
Plot-wise,
A.
details of compensation. Yes.
And ITCO also has written a letter that we will pay you.
So, Mr. Naik, you take instruction in this matter. This writ petition has been filed, but it is coming for the first time.
Yes, Your Lordship.
By Messrs. DV Steel Industries Private Limited to its director with a prayer for a direction to the respondent number 1, that is Special Land Acquisition Officer from Sub-Collector Sadar Sundargarh, to pay compensation amount for the leased plot by the ITCO plot numbers 18, 19, 20, 20 by 1.
20A, Your Lordship.
20, you have
A.
mentioned 20 by
1 you
in
have
the
written, but
prayer
that is
portion.
20 by A.
20 by A, bracket रे consisting of, देखिए देवे prayer portion acre number so and so, है ना, comprising an area measuring so and so लिखी देवे, है ना. The land council for the petitioner submitted that though the petitioner has received the structure value, but he has not been paid, he has not received the payment for the aforesaid 4 plots. And when he submitted the application before the authorities under RTI, the reply was given under annexure 11 series that the award register of village Mondia Kudar
Manya Kudara.
Mandia Kudar indicates that plot numbers 18, 19, 20 are not acquired by the government for expansion of SH10 in 2014. And another letter was received that plot number 18, 19, 20 and 20 by 1 of village Chungi Mati, Kansa Bahal, Sundargarh, Odisha, has not been acquired for expansion of SH10 through IDCO Raurkela in the year 2014, and no award has been passed against the said plot. The Land Council for the petitioner further argued that the information which has been supplied to the petitioner by the authorities is completely erroneous, which would be evident from Annexure 3 series, where the plot-wise details compensation for land acquired has been mentioned, and in page number 46 of the writ petition, in serial number
11, 12.
11, 12, 13 and 14, the aforesaid 4 plots find place as IDCO plot numbers. And therefore, the petitioner is entitled to get the relief sought for. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. You accept notice for all the opposite party?
Except for IDCO, my lords.
IDCO.
IDCO has a separate panel.
Opposite party number 2.
My lords.
Land Council for the state accepts notice for opposite party number
1 and 4.
1, 3 and 4.
1 and 4, my lord.
1 and 4.
My lords.
So far as opposite party number, extra copies be served on ones. So far as opposite party number 2 and 3 are concerned, Mr. Pradeep Kumar Mahanti,
They have a panel, my lords.
Different panels.
Send notice requisites to be filed by Monday and matter to be placed after 4 weeks. Yes, counter affidavit if any be filed in the meantime.
Obliged.
Item 5.
May I please, Your Lordship? While considering this matter on 11/9/2024, Lordship passed the order. Your Lordship may kindly see.
11/9/24.
11/9/2024.
Just a little. Okay. Please read out the order.
My Lord.
No, why are you not using this? 11/9/2024 order ବାହାରିଲା ତା ଦେହରେ ସେ ଅଛି ସେଠି ହେଲ୍ପ କରିବା ପାଇଁ order number 1 11/9/24
11/9/11/9
ଛିଡା ହେଇଛି କାଇଁ ସେଠି
item number 5. The petitioners, namely Ashok Kumar Mahanti, Gopal Krishna Behra, Srimati Vaijayanti Mala Nayak, and Prafulla Kumar Samal have filed this writ petition for passing of the order dated 27/4/2024, passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 50 of 2021 under Annexure 1, dismissing their original applications. While dismissing the original application, the tribunal has taken into account bylaws of the NWDA vis-a-vis the decision of the Honorable Supreme Court in SLP number 3106 to 3107 of 2012 and SLP number 20425 of 2011. So also with the case filed before the CAT Principal Bench, Delhi, by Sri Rohit Kumar Sethi. Learned Counsel for the petitioner submitted that though in the aforesaid decision it has been held that the employees of the NWDA are to be governed by the National Water Development Agency Contributory Provident Fund Rules 1982 and not Contributory Provident Fund India Rules 1962, but NWDA has not framed any CPF rules 1982 and such a rule is not in existence, and therefore the petitioners are to be governed by the CPF rules 1962. Mr. Bimbisar Das Lanan, Senior Panel Counsel appearing for the Union of India, receives a copy of the writ petition in court today. Let Mr. Das obtain specific instruction as to whether there is any such rules, namely National Water Development Agency Contributory Provident Fund Rules 1982 or not. And if it is in existence, produce the copy of the said rules on the next date, which is fixed to 24/9/2024. And thereafter,
They took time, and on 2/12/2024, you have been asked.
then 4 dates they have to.
What is Mr. Pari?
In the last date, Mr. Padi had said that he had received
On that.
He said that he is having that rule and he will file it.
in the shape of an affidavit. He wanted to file it.
They have called for some officers and discussing preparing my
No.
learned senior.
Why it has-
What is the problem?
Time they are
There is
taking.
any problem or what? He was just here.
Call.
He was seen in virtual mode.
Yes, yes, sir.
But as per my instruction, today they have.
No, he made a specific statement
Yes,
that
my
the
lord, my
rule
lord.
is in existence. I have received the copy of that rule. I'll file it by way of an affidavit. That's
My lord, I was
so-
also present on that.
Before that, your lordship will see only 2 documents.
Just a minute.
No.
Let us.
Your entire matter rests on that.
No.
If that rules is before us, then your matter is over.
But I want to know, I want to submit to show 2 documents, their documents, where they have specifically admitted.
That we
there
have
is-
already heard. We have already heard you. Detailed order has been passed.
My lord, Leonard DSJ is in the court number 1 on hearing, therefore
Okay, you're passing it over.
passing.
Okay.
Item 6.
May I please, your lordship? Last
Yeah.
occasion on 2/12/2024, my lord, Government Council is
I had to obtain instructions, my lord. I have obtained the instructions.
This contention was, Mr. Nayak,
My lord.
that there is nothing in the Forest Conservation Act
My lord.
that Kochi Ravana comes within the forest land. That
Well.
was his submission.
Yeah.
That was your submission. And you are to reply to it.
My lord.
Learned Counsel for the petition submitted that Learned ADM Bhubaneswar, that is the order dated 28/10/2020,
And that is the exhaustive order.
has considered so and found that the lease suffers from different defects. Inter alia, classification of the land in the Sabi Karwar is Kochila Bono, which means that it was forest land. But the Tahsildar on Swanso mentioned in the order sheet that the classification has been changed from Kochila Bono to Puratano Patito by mutation proceeding number Swanso, and ROR has been accordingly corrected. As for the Swanso, the Tahsildar is not competent to sanction the forest land without obtaining NOC from the government of India. It is the contention of the Land Council for the petitioner that there is nothing in the Forest Conservation Act that Kochilabona comes within the forest land. State seeks some time to obtain instruction in that. Yes,
My lord. The second page, my lord. The reverse page. I'll give a copy.
let it be copy, sir.
Copy देवे ना उसी के अंदर reply देवे कौन लिखते हैं अपन
My lord. The reverse page, my lord, half of that page. It is submitted at section 2C of Communal Forest. It
Yes.
is submitted that Section 2C of Odisha Communal Forest and Private Land Prohibition and Prohibition of Alienation Act defines forest land includes any wasteland containing shrubs and trees and any other class of land declared to be forest land by notification of the state government. Subsection 1 of Section 3 of the Act provides, notwithstanding anything contained in any other law for the time being in force, or any express or implied agreement, and subject to the provision of subsection 2, no landlord shall, without previous sanction of the collector, sell, mortgage, lease, or otherwise assign or alienate or convert into royalty land any communal, forest, and private land, or create occupancy therein. Similarly, Section 4, subsection 1 of the Act provides, any transaction of the nature prohibited by Section 3, which took place on or after the first day of April 1946, shall be void and shall not confer and take away or be deemed to have conferred or take away any right whatever on or from any party to the transaction. Further, on verification, it is found that the suit leasehold land pertaining to Khata number 343, plot number 41 of Moja Samsundarpur comes under the district level committee list of Khurda district. Hence, the suit land comes within forest land of Khurda district. In view of the above, it is submitted that classification of land Kochilabana may be treated as forest land and prima facie objectionable for grant of lease without obtaining NOC from Government of India as per the Forest Conservation Act 1980.
No, you come to again that particular 3 to 4 sentence that words that forest land includes any wasteland containing shrubs and trees and any other class of land declared to be forest land by notification. So whether that particular land which has been given to the petitioner that was declared to be the forest land by notification of the
Whether there is a notification to that effect.
unless there is notification, you cannot.
And that is the answer, in fact, which has been awarded here. If that notification is there, your answer is clear.
ଆପଣଙ୍କର କୋଉଠି ଗୋଟେ ବୁଦା ହେଇଯାଇଛି ତା ମାନେ ନୁହେଁ ଯେ ସେଟା ଅଟୋମେଟିକାଲି
Forest
ଫରେଷ୍ଟ
land.
ଲ୍ୟାଣ୍ଡ
There has to be a notification
Unless a
declaring that as a
that clarification
I'll
again
opt
you
it.
are to require to obtain.
My lord.
Okay, that you particular କହୁଛନ୍ତି
Declaration. Kochilabana.
Kochilabana.
My lord.
But give a copy of the.
I'll
I
give.
want further clarification
My lord.
from you.
My lord.
ଲେଖନ୍ତୁ
That is how he is also saying that the classification of land Kochilabana may be treated as forest land.
The in pursuance of the order dated 28/10/2024, the Land Council for the state has produced the written instruction received from Tahsildar Bhubaneswar dated 30/11/2024, wherein Section 2C of Odisha Communal Forest and Private Land Prohibition of Alienation Act has been quoted. So also Section 4(1) of the said Act and it is stated that on verification, it was found that the suit lease hold land pertaining to Khata number 343, plot number 41 of Mauja, Samsundarpur comes under the DLC list of Khurda district. Hence, suit land comes within forest land of Khurda district and the classification of land Kochilabana may be treated as forest land. Kochilabana inverted comma ভিতরে রাখিবে, forest land টা inverted comma ভিতরে, and prima facie objectionable for a grant of lease without obtaining NOC from the Government of India as per Forest Conservation Act 1980. Let a copy of the written instruction be served on the Land and Council for the petitioner. When we put a pertinent question referring to the section 2C of the aforesaid act as to whether the land appertaining to khata number 343 and plot number 41 of Mauja, Samsundarpur has been declared to be the forest land by notification of the state government. The Land and Council for the state seeks some further time to obtain instruction in that respect. Put up this matter after date দিয়ে দেবে হ্যাঁ second week or yes.
May I prefer a copy of the order?
Free copy of the order be handed over to the land.
Item 7.
There is a representation, but it has been filed long back in 2020.
Your representation is of the year 2020 and 2021.
21.
You file a phrase one giving all the details within a period of 2 weeks so that it can be disposed of.
Yes, ma'am.
Right. This writ petition has been filed by the petitioners with a prayer for a direction to the opposite party number 3, Land Acquisition Officer Puri, to take appropriate action on the representation filed by the petitioner on 21/2021 by Annexure 4. Petitioners submitted that the petitioners may be given an opportunity to file a fresh representation giving all the details and the same may be directed to be considered by the opposite party number 3 in accordance with law. The Land Council for the state has no objection to such submission. Considering the submission made by the Land Council for the respective parties, the petitioners are given liberty to file a fresh representation giving all the details before the opposite party number 3, Land Acquisition Officer Puri, within a period of 2 weeks from today, in the event of which the same shall be considered by the opposite party number 3 and decision taken within a period of 3 months from the receipt of the representation, and within a period of 2 weeks if they are to communicate, the opposite party number 3 shall communicate the order decision taken to the Swanson. It is made clear that we have not expressed Swanson a copy as a representation along with a copy of the order and the copy of the writ petition to be produced before the opposite party number 3. Then 3 months and 2 weeks for disposed of. Yeah.
Obligement.
Item 8.
Items 8 and 9. Similar matters, my lords, is already dismissed because of delay and latches. The similar order.
Same order to be passed.
Item 10.
Your Lordship, item number 10, all the sub-items are covered matter, Your Lordship.
Please give the one of the order. Any change is necessary?
I have
You
mentioned.
have indicated.
Now, there is some discrepancy in the sub-items. May I, my lords, point it out. Item number 10, for example.
Yeah.
This is 29698.
Yeah.
If my lord checks the affidavit, this petitioner, Puspa Gowda, is aged about 52 years. Affidavit is at page 7, my lord.
Yes.
My lord. If my lord comes to the compensation that is granted by the learned civil judge, Puspa Gowda, this is at page 9.
Page 9 here.
My lords. My lords will come to serial number 5, Puspa Gowda.
34.
Aged about 34 years. So is this the same person?
No, this order, this was passed in 2006. The MJC was of the year 2006, and this affidavit which you are placing now, it is of 2024. So in the meantime, 18 years have passed.
That is
That may be the reason.
And the name of the father is all right.
Father, ठीक है, एक पॉज वगैरह को.
His Aadhaar card actually it is Pushparaj Ghee. He has.
That's all right.
That's all.
And this one also, my lords, 30527.
So this is for this first one.
First one.
Then any doubt?
The third one, 30527 of 24. Tikkemani Nag.
Okay. Third one, okay. 30527 the third one.
Tikkemani Nag.
My lords.
So
if my lords, in that application, look at page number 9.
Page number 9.
Tikkemani Nag's name is not here. This 6th of January 2018, this award.
Tikkemani Nag.
No.
Eight ଗୋଟେ genuine name. ସେଇଟା କଣ ଆପଣଙ୍କର ଆସିଲା? Tikkemani Nag. ଆଉ ବାକି ଗୁଡାକ ଅଛି କେତକୀ ପ୍ରମିଳା ଅଛି. କେତକୀ ପ୍ରମିଳା ଅଛନ୍ତି?
ନାହାନ୍ତି.
ଏଟା କଣ ଆଉ ଗୋଟେ କଣ ଆଣି ଦେଇଦେଲେ କି?
Ramji Lal Gaur is the father of Tikkemani Nag. I have mentioned in the
Have you mentioned it?
In the petition, I have mentioned that the petitioner whose family
ये
line
the
has
son of लिखଛନ୍ତି Ramji Lal.
Ramji Lal.
बाकी जो केतकी गौड़ किए?
Wife of Prasad Bagarti. Prasad Bagarti was
how the writ petitioner number, petition number 2, Ketaki Gowda has got any link with that MJC order?
He is the wife. She is the wife of Prasad Bagarti.
Prasad Bagarti ना रे तो MJC ये जो LAR रे किसी है नहीं, LAR number जोड़ा annexure 1 ଦେଇଛନ୍ତି ତା ଦେହରେ କାହିଁ ତା ନା? Ataki. Pramila Gowda. Pramila Gowda na ଅଛି.
Nice. Repetition or nine?
Yeah, petition number 3. Pramila Gowda, son of Bono Yadav.
May I please, your lordship, means as per instructions what I have received, your lordship, they are the sons of the petitioners in the reference court. So the present petition number 1 is the son of petition number 1 of the LAR case in the reference court.
You kindly mention in a paper
yes, your lordship,
how they are related.
Yes.
Then have you mentioned in the any paragraph of the?
I have actually mentioned as a common the petitioner's family's land has been taken. I have
That is not.
I have not specifically mentioned, your lordship.
We file an ଏଇଟାକୁ ଆମେ segregate କରିଦଉଛୁ. ଆପଣ ଗୋଟେ by way of an additional affidavit ଆପଣ ଦିଅନ୍ତୁ.
Yes, your lordship.
ଏଇ ଯୋଉ LAR case ର ଯୋଉମାନେ ଅଛନ୍ତି petitioners ତାଙ୍କ ସହିତ ଏଇ ଯୋଉ writ petitioner link ଟା କଣ? ହେଲା? ତ ଏଇଟାକୁ ଏଇଟା ଆମେ this
the second sub item.
ଆଉ କିଛି ଅଛି କି ମିଷ୍ଟର?
ନା ଆଉ କିଛି.
ଆଚ୍ଛା ଏଇ ଯୋଉ covered matter ରେ
so only 2 items can be taken.
No. 1 2 3 4 5 ये पांचटा ये गोटे केवल से
जीवो.
30527.
Where is the order?
I have
You have given me. ठीक है. अपन सुनंदु.
That relates only to one.
WPC जो 29698 तापरे 30496 30535 31465 and 31476 या संगरे से ऑर्डर देखिन पास कर देबे. गोटे मैटर केवल 30527 of 2024 रे लेखंतु. Mr. Naik and additional government advocate submitted that the petitioners in the LAR case number 52 of 2013, which was in which judgment has been pronounced by the London Civil Judge Senior Division Dharamgarh, and the petitioners in this writ petition are different, and no averments have been taken in the writ petition as to how they are connected to each other. At this stage, Land Counsel for the petitioner submits that he will file an additional affidavit indicating the relationship between the three petitioners of this writ petitioner with the petitioners in LAR number 52 of 2013, giving a copy to the Land Counsel for the state. List this matter immediately after the additional affidavit is filed, right?
Yes, sir. Obliged.
Item 11.
May I please? Your Lordship, come to page 16.
What is your prayer, Mr. Das?
My prayer, Your Lordship, this is the second round litigation. In first, my Lord, I have annexed the order. That is page starting from page 14. After obtaining that order, my Lord, I have produced the certified copy before.
First time when you approach this court,
My Lord,
as it appears that
page 17.
order was passed directing the OP3 to dispose of your representation.
My Lord,
within a stipulated
my
time.
Lord, even though I have produced that copy, the Tahsildar also directed to the RI. I have got its unauthorized copy.
Dispose of Helani ki?
Till today, they have not taken any action, my Lord.
Say representation, I would
Say representation. Even though the Tahsildar has directed to the RI to submit a report on 24/9/2024.
Naik,
My Lord.
seek instruction.
I'll
There was a specific direction.
Yes.
And the time stipulated is already over. Right. Look on. The Mr. Das, Land Counsel for the petitioner, submits that relating to non-payment of fair compensation and benefit of rehabilitation and resettlement in favor of the petitioner in spite of acquisition of land. The petitioner earlier approached this court in WPC number 17810 of 2024, and this court by order dated 37/2024 has been pleased. Has been pleased to dispose of the writ petition directing the Tahsildar Ostaranga Puri bracket opposite party number 3 in the said writ petition to consider the representation in accordance with law within a period of 3 months from the date of production of the certified copy of the order. The London Council further submits that even though the time stipulated in the aforesaid order has is already over, and the opposite party number 3 has received the copy of the order of this court, but no response has been received by the petitioner relating to the result of the representation. Stop. At this stage, Mr. Nayak and additional government advocate seeks 2 weeks time to obtain instruction about the status of representation filed by the petitioner. Put up this matter. Second week. Yes.
Obliged.
Item 12.
May I please, Your Lords?
In this case, my lord, the petitioner has approached the Honorable London Central Administrative Tribunal for the following reliefs at page 33, my lord. Page 33. Relief sought to quash
33.
Page number 33. My prayer before the cat.
Okay.
To quash and set aside the communication dated 13th May 2013, Annex A by 6, letter dated 16th May 2013, Annex A by 7, and the letter dated 20th December 2016, Annex A by 9. And second, to direct the respondents to continue disbursing payments, remuneration, wages payments to the applicant against his employment as per standard terms and conditions prevalent and being followed for the time being in the circumstances. To consideration regularization of the applicant against Group C vacancies, the department taking into consideration his educational qualification and experience. That is my prayer before the Central Administrative Tribunal. So far as prayer number 1 is concerned, my lord, the same tribunal has already quashed those 3 letters which is issued by the CBDT. That is in 3 cases. I have already bring a compilation of 3 judgments we have already cited before the tribunal in my written note of submissions. And in my written note of submission at page Annex 8, page 46, my lord.
No, those you say that similar orders were passed
Already passed.
and you also brought it to the notice of the tribunal.
My lord.
Has the tribunal referred to those orders, previous orders?
They have not, tribunal has not dealt it at all. Even if it is own tribunal order. Even if it is own tribunal order and principal bench tribunal order.
Then what are these judgments which has been relied upon by the tribunal? One of the Honorable Supreme Court in case of Uma Devi, of course. The second one is Radhesyam versus GNCT Delhi. And ultimately, they come to that operative part of that order at page number 55, paragraph number 6. Please read it out.
It is not the case the applicant that his initial engagement was after following due process of selection as per rule or against any sanction post. The engagement of the applicant as admitted by him with effect from 1st October 2011 do not fall within the scope and ambit of exceptional clauses for one-time relaxation as made in the decision of Honorable Apex Court in Uma Devi. We have gone through the decision relied on by the applicant, but we find that in view of the decision of the Honorable Apex Court quoted above, the case of the applicant falls to the ground. But the same tribunal in other cases and also passed the order by questioning.
No, the other cases, Uma Devi case was taken into account.
My lord.
So where is that? Where are those orders?
I have already.
And whether those orders were still in force or that has been challenged before this court. These earlier orders which you are referring to, that in some other ways, in similar cases, the tribunal has given relief to those petitioners. Whether that has been challenged before this court.
My lord, not challenged.
Not challenged.
Not challenged till date.
Where are those orders? Please.
These orders.
Have you annexed those orders?
So I prepare this submission. If that's taken any other date, it is.
All right. Please bring those orders.
My lord, later.
Because what we find that the Planning Tribunal has taken note of your decision, but says that since Apex Court decision in that Uma Devi case is there, so obviously the petitioner cannot get any relief. So your engagement was in 2011. You are still continuing.
I am still continuing.
So that means more than 13 years.
I am continuing.
Right. How did you get that? Whether he said that there was no sanctioned post also at that point of time. What was your post?
Tax assistant. Casual tax assistant.
Casual?
Tax assistant.
Task assistant. How you are selected? On what basis? Kini rokhidala na kon kichi gote kichi minimum kichi follow
heichi? There is a need-based requirement of the department, for which department has taken so many people into their contestant. Minimum 200 to 300 employees are working. I am not single one. Everybody is now continuing as per the decision of the principal bench Delhi.
ଠିକ ଅଛି ଗୋଟେ କଣ୍ଟ୍ରାକ୍ଚୁଆଲ ଇଏ ପାଇଁ ନେଇଥିଲେ ଆପଣଙ୍କୁ ସେବେଠୁ ଆପଣ କାମ କରି ଆସୁଛନ୍ତି
Madam.
but the Uma Devi case has been referred to there in that relevant paragraph has also been extracted in page number 53 and 54.
That is, my lord, prior to 2006. That is separate issues, my lord. That is when at that relevant point of time, those who are working more than 10 years, government has to make a scheme and they will regularize in their service. That decision is 10 years back decision, my lord. Basing on Uma Devi case, the CBDT has issued instructions, and those instructions has caused by the learned principal bench Delhi as well as this bench in so many cases. I have already given the charts. Minimum 200 to 300 employees are working.
No, you give those decisions.
I already submitted, my lord.
Listen, you give a copy to the also the union.
My lord, I am giving the.
Have you given to the union of
Nobody is there.
He is there. Listen, the writ petition has been filed by Bashant Kumar Malik, petitioner Bashant Kumar Malik, for passing the order dated 4/9/2024, passed in way number 85 of 2017 by the London Central Administrative Tribunal, Cuttack Bench, Cuttack. Way number as it appears, the petitioner filed the aforesaid way inter alia with prayer to set aside the communication dated 9/13 May 2013, later dated 16/5/2013, later dated 20/12/2016, with a further direction to the respondents to continue disbursing payments, remuneration, wages, payment against his employment as per standard terms and conditions prevalent, and to consider the regularization of the applicant against grade C vacancies of the department, taking into account his educational qualification and experience. So, the London Tribunal, in the impugned order, after taking into account the ratio laid down by the Honorable Supreme Court in the case of Secretary State of Karnataka and others versus Uma Devi and others, 2006-4 SCC page 1, and Radhesyam and others versus GNCT of Delhi and others in WPC number 471 of 2015 dated, decided on 22/1/2015, has been pleased to hold that the engagement of the petitioner with effect from 1/10/2011 does not come within the scope and ambit of exceptional clauses for one-time relaxation as made in the decision of the Honorable Supreme Court in Uma Devi Supra. And even though some decisions have been relied upon by the petitioner, but in view of the decision of the Honorable Supreme Court, the petitioner is not entitled to get any relief, and accordingly the OA was dismissed. The Land Council for Subpara, the Land Council for the petitioner, produced before this court the decision taken by the Central Administrative Tribunal principal bench in different ways. Principal bench as well as Cuttack bench in different way, which are taken on record. The copy of the same has also been handed over to the Land Council for the Union of India, who seeks some time, who has already received the copy of the writ petition and seeks some time to go through those orders. According to the Land Council for the petitioner, the aforesaid orders passed in the original application by the Central Administrative Tribunal Cuttack bench has never been challenged before this court in any writ petition. Land Council for the Union of India shall also obtain instruction in that respect. Put up this matter on such and such date.
Status quo status quo maintain.
You are there, you are
I
continuing.
am continuing.
It is stated by the IL number 1 that the petitioner is continuing in service since 1/10/2011 till next date he shall not be disturbed. Yes.
Item 13.
For study the matter on my notes board. That's the exact matter where the guarantor repaid the entire amount, 1,27 lakhs. And by guarantor takes the position of the borrower in view of section 128 of the Contract Act, read with section 2A.
Mr. Sahu. So what is your instruction, Mr. Sahu?
Present.
Ah.
Lord, they will file a letter of indemnity.
Use the mic, we are not able.
They will file the letter of indemnity and stating therein that all the future liabilities and claims against these.
No, whatever you are making a oral submission, please give it in writing so that Mr. Ratha can take instruction from his client.
Or he will file the indemnity bond in accordance with your
Whatever
condition.
you say
Yes,
that
yes,
this
yes.
is your proposal.
Yes.
Suppose it is acceptable to the petitioner, it can be disposed of, right?
Yes, yes, please.
So you are interested for your money and all these things. He is also interested to solve the problem. So give it in writing. Can it be possible by tomorrow?
Yes, my lord.
Just give it in that what you want actually, how the petitioner can get the relief. So we are noting that the manager is present.
Yes,
Please give the name so that
yes, my lord.
the Mr. Mr. Pune Sahu Land Council appearing for the opposite party's bank is present. He also submits that this one, so is the manager's account is present, and he intends to file an affidavit as to how the problem faced by the petitioner can be sorted out. Put up this matter tomorrow.
My lord.
Yeah. All right. So to mention that Mr. Ross, the learning senior advocate for the petitioner is present. Yeah. So we will just come in. We are coming within 2 minutes.
Item 15.
Only direction to the Tahsildar Khordar dispose the representation by annexation number 3 of dated 4/5/2025 of page number 21.
All right. Presentation disposed of. Annexure 3 of the representation, Tahsildar. Yes, next.
Item 16.
Miller. And the case is that the petitioner, the land loser Miller, his 3 decimal homestead land has been used for extension of the and the construction of the Panchayat road. That is
You have submitted a representation
yes,
under
Miller.
Annexure 3.
Annexure 3.
That is dated 9/8/24.
24 because the 23.
No, it's all right. Have you got any response from the authority?
There is no response. Your Lordship, turn to page 5,
2.
paragraph 7.
All right, all right. Let him dispose of the representation. Opposite party number 2
To collector Bala
to dispose of the representation under Annexure 3. All right.
Oblige.
Item 17.
Item 17 some the coached person released on bail by the Honorable Court, my lord. That is criminal appeal 8722 of 2022, my lord. Earlier also been also directed to State Council on 14/11/24, my lord.
Guilty under sections?
Guilty under 302 is there.
302.
Yes,
302.
And since no, it is there are other offences.
That 307, 302, 404, and 201.
376.
376, sorry.
No.
376, 302,
376.
404, and 201.
So
The Khali Thala 14, he will also directed on 14/11/2024. Present feature similar footing or not. One co-accused maler, Chakra Dami maler. Pilots.
where is the bail order copy? It's a case of rape and murder.
Rape and murder.
So, what are the materials against you?
There is last scene theory, maler. There is confessional statement of
Just tell us the circumstances.
yes.
Preparation, case is out there. Yes, ma'am.
Item 18.
My lord, on behalf of Mr. my lord, the paper book not received, my lord.
Paper book.
We have received the paper.
My lord, item 18, my lord, I am appearing on the basis of a business petition, my lord.
You have already filed your Bhinam, Mr. Nayak,
Yes, my lord, I have filed.
and that is also accepted. Okay. And you have received the paper book?
Yes.
Okay.
Okay.
Is a sole appellant.
Sole appellant.
Since Mr. Biswajit Nayak has already entered appearance, and filed Vinama. The name of Mr. Sabyasachi Misra and P.K. Behra shall not be reflected in the cause list henceforth. Yes, argue the matter.
An application for bail, Miller. Custody certificate is required, Miller. Lordship, kindly call for the custody certificate.
Custody certificate. The IA number so and so, there is an application for bail. The Land and Council for the appellant petitioners submits that he has got no exact information regarding the custody period of the appellant, and therefore the Land and Council for the state may call for the same. Stop. Let the Land and Council for the state call for the produce the custody certificate of the petitioner on the next day. Obviously, it would go to the January 2025. Yes.
Item 19.
Miller, in item number 19, Miller.
I may submit my letter. 312. Lordship directed to obtain the case, criminal antecedent and correctness of the address of the appellant, which belongs to Jharkhand. But we have sent the letter, but not yet obtained.
You require some further time.
Miller, his
Land
father.
Council for the state submits that in pursuance of the order dated 3/12/2024, instruction has already been sought for, but it is awaited and the matter may be taken up after reopening of the court of Xmas holiday. Court of this matter on such and such day. Here.
Item 20.
Mr. Devasnan Das. Not there. Next.
Item 21.
My lord, directed to obtain the custody certificate. Custody certificate already obtained, my lord.
Oh, where is Mr. Koro? The password for
Item 22.
My 22, may I please, Your Lordship? I hear Your Lordship was pleased to dispose of the case that the matter will be taken up by the DRT. Your Lordship fixed a time limit of 2 weeks. In fact, when the petition for amendment is there, he is not able to consider, he is not considering anything, the land tribunal. But I am only praying, man, Your Lordship may grant a reasonable time and extend it so that he considers everything. Because if he decides it without my lord considering anything, only on the basis of my lord, he is not deciding the petitions, the case was posted.
Mr. Mishra,
My lord.
Your essay number is 161 of 2023.
My lord.
So there may be old cases also. How can we say that a 23 essay would be disposed of and other old cases would be pending? Why don't you move the Land and DRT for expeditious hearing? And
no, I am not praying for expeditious. Since Your Lordship fixed the time limit to 2 weeks, he is not hearing any application. That is my grievance.
He has heard, my lordship.
No, let me assist the Honorable Court thereafter my explanation.
Dispose of the matter earlier. Because
No,
Your Lordship, they have gone to DRT and DRT has passed an order
just clarify then the background.
vacating the interim order. Thereafter, Your Lordship has directed the SS should be heard because sale has been done, sale has been confirmed. For that reason, Your Lordship and sale certificate has been issued.
Let me just clarify, my lord.
Directed to dispose of the essay within 2 weeks because they want the interim order.
It is my petition, my lord.
When the purchaser is awaiting possession of the purchased property for a period of more than 2.5 years, my lordship.
Mishra says that it is his petition. He has to move the petition. Mr. Mishra, you can come tomorrow. We are taking up.
My lordship, you serve a copy of the IA, my lordship.
My friend is there. Must have given copy to them.
Please this matter tomorrow as prayed for by Mr. Sanmeer Kumar Mishra and senior advocate. Let a copy of the interim application be served on the Land and Council for the
opposite party number 4, auction purchaser.
Party number 4. You have received the copy?
Yes, just now.
During course of the day, yes.
Item 23.
Yes. Mr. Party, yes.
Term 5 my lord is past due.
5. Where the rule was to be produced.
No, where is the council?
I have. UPT is coming with another instruction.
You said that you will file it by way of an affidavit.
But it is not legible and I have that copy. This is before, but it's not a legible copy to read. I asked the officer to give in proper copy. He could not
What
give.
you want, Mr.
I after vacation, if you possible, then it's 3rd, 4th, 5th, any date.
All right. The bring that item number 5.
Yes.
5 number.
2/12/2024 order.
Before that, if your lordship will at the glance, 2 documents only, Miller.
No, we'll just have that, then we'll hear the
For
matter.
that only I was saying.
The Learned Counsel for the Learned Deputy Solicitor General, Mr. Padhi, submits that though he is in possession of what is that rule?
That is National Water Development Agency.
National Water Development Agency. Contributory Provident Fund Rule.
National Water Development Agency Contributory
Provident Fund
Rules. Contributory Rule 1982. ହେଲା ଆପଣଙ୍କର order dated 11/9/2024 ରେ rule ଟା mention ହେଇଛି, right? 11/9/2024 ଆଉ ଥରେ କହୁଛି National Water Development Agency Contributory Fund Rules 1980 ହେଲା but this
1982 sir ଲେଖା ହେଇନି ଖାଲି ଲେଖା ହେଇଛି control rules, then it shall be should be divided
it might not have been mentioned in your notification.
It was 82, but on the rule
question is 1980.
Yes.
But
effect from 82. Yes.
But the same is not legible, and therefore the matter may be taken up after ensuing Xmas holiday to file a legible copy of the aforesaid rules with an affidavit.
Yes, ma'am.
Giving copy to the Learned Counsel for the
petition. No, opposite party.
Petition. Put up this matter, such and such. Yes. Along
Obliged.
with you on the
It's my pass on the list, my lord.
Yes. That list is there.
No, I'm list.
ଆପଣଙ୍କର କିଛି କହିବା
Pass on the list. Yes, my lord. Good.
The last chance. No further time.
It's all right.
Definitely, I'll.
Teaching on now, what are the
Obliged, my lord. I'm sorry, I will interrupt.
That's all right.
Item 23. Your Lordship, I am for the petitioner. Your Lordship, due to an oversight, there was a delay in filing of the requisites. I have filed the requisites today. Your Lordship may fix a date for hearing.
You have already filed.
Yes, today I filed it, Your Lordship.
The Land Counsel for the
On behalf of Mr. Mukherjee,
petitioner, what is your good name, madam?
Ankita Mukherjee.
Ankita Mukherjee submits that requisites for issuance of notice as per the order dated 12/11/2024 has already been filed today, and the same may be accepted by the registry and follow-up action may be taken. Registry shall accept the requisites and proceed. Stop. List this matter on 16/12/2024 as earlier directed. Yes.
Your Lordship, interim order to continue.
What is the interim order?
Your Lord, IA number 12169.
Okay, the interim order dated so and so passed in IA number so and so. I'll continue till next date. IA number 12169 of 2020. Okay.
Obliged. Item 24.
Adjourn hitla 16/12 को 16/12 को adjourn hitla. It is present matter.
See, requisite put a limit, time limit with a fee.
Next adjourn to maila
3 dates. We are no 16/12.
12. 16/12. 16/12. List the matter week commencing 16/12.
Wait, 16/12 then you do it second Second week of January for them to take the finishing model is explained. And what is the January? Second week of January 2025 to date.
Item 24.
My lord, I have already filed the consolidated title, first title, my lord, it is received by Government of India. My lord's order dated 1/10/2024, so directed to take instruction in this regard. So whether it is, and I have
Order dated
1/10/2024. My lordship order, at that time, my lordship directed to take instruction. But he objected that you give the cause title correctly, so my lordship allowed me, and I filed the correction amendment, and it is allowed, and I have served a copy, and it is also tagged as everything I have completed. Then, my lord, they will take instruction.
For implementation of order dated.
you are to file the consolidated cost title.
Yes, my lord.
You have already filed.
Yes, already copy served. In the second time, say, file nothing ବୋଲି ଆଉ ଥରେ ଗୋଟେ ଦେବି.
All right. So you have received that consolidated. Yes. Then argue the matter.
But
So it has come only for that purpose.
it is in the orders. It has come before my lordship today in for orders whether complied or not.
No, it's all right.
So that's
just a minute. Let us see.
This is tomorrow on Monday.
Number 15740 of 2024. This is an application filed for amendment
My lord.
of the correction of the cost title of the writ petition by reflecting the designation of the competent authorities as opposite party number 1 to 7
My lord.
as described in the proposed schedule of amendment. The learning counsel for the opposite party has no objection, and accordingly the prayer made in this interim application is allowed. Now the schedule of proposed amendment shall form a part of the petition. The learning counsel for the petitioner has already filed the consolidated cost title, which is accepted. Copy of the same has been served on the learning counsel for the Union of India. Put up this matter for admission. It will come.
Oh yes, my lord. That's why I pray, my lord.
This IA is disposed of. What is the other IA you have filed?
I am not filed. This is for deletion of party.
That's already there.
Order passed today. The IA is disposed of.
15740.
In view of the order passed in
No.
one
It will say 16787.
disposed. 15740 2024 order ଆଜି जो pass ହେଲା ସେଥିପାଇଁ ଏଇଟା dispose of ହେଲା lecture.
Reopening.
It will come in the second week of January 2024 for admission.
Pension holder, my lord. Retired person.
No. Next week there is only 2 days.
Not pressing, my lord.
Yes, next.
First week.
ମଧ୍ୟ 2 ଦିନ ଅଛି ନା କଣ?
Second week, my lord.
Yes.
Obliged.
We are directing.
Second.
Yes.
Obliged.
Item 25.
My lord, in item 25, my order dated 4/12/2024.
Where is Mr. Kanungo?
Yes.
My lord directed to produce the will miscase number 23 of 13, but in the order it is wrongly mentioned 23. Letter was issued on 5/12/2024.
No. The number is not 23.
13.
13. अच्छा.
13.
23 of 2013.
अच्छा भूल नहीं.
आगरू 13 अच्छी. Previous order है. 23.
My lord, letter was issued to the.
Just a minute. Prayer is लिख दो. WL 23 तो आपण भी लिखचंदी. You see the prayer portion of the writ petition.
Yes, written, but 13.
Mr. Kanungo,
Yes,
is
my
it
lord.
correct that your number which has been reflected in the prayer portion as 23 of
2013.
it is incorrect and it is actually 13 of 2013.
affidavit जोटा फाइल ହେଇଛି ତହସିଲଦାରଙ୍କ ତରଫରୁ 13 ଲେଖା ହେଇଛି.
ଟିକେ ରୁହନ୍ତୁ କାଳେ ଅଲଗା କଣ ହେଇଥିବ ଆପଣ ଏଇଟା ଆପଣ ଆସନ୍ତୁ annexure 7 କୁ ଆସନ୍ତୁ. Annexure 7 ପୁରା ଉପରେ ଲେଖା ହେଇଛି.
Annexure 7 ରେ WL miss case number 23 of
ହଁ
2013.
2013 ମସିହାର କେସ୍ କିନ୍ତୁ ନମ୍ବର ହଉଛି 23. ଆପଣ ଭୁଲ କେମିତି କହିଲେ?
ନା ନା ଇୟର ଟା ପଡି ଯାଇଛି ଏଠି ଅର୍ଡର ରେ ଇୟର ଟା ଭୁଲ
ହେଇଯାଇଛି.
23 of 2013 ଯାହାର.
ଓହୋ 23 ହେଇଯାଇଛି. What do you want further?
time my lord letter issued to the authority to
produce that records.
My lord.
All right. The Lieutenant Counsel for the state seeks some further time to produce the records of WL miss case number 23 of 2013 लिखिबो. ହେଲା ठीक तो list this matter second week of January 2025.
Interim was there.
Mr. Milan Kanungo and senior advocate is present. Yes.
My lord, sir, may I pray that it be taken as a last chance? 3 times they have taken to produce.
Mr. Milan Kanungo and senior advocate appears so and so opposed to the prayer for adjournment. List this matter so and so. It is made clear that no further adjournment shall be granted. Here.
17th, my lord.
It will come in the third week of that. Third week of them. Third week of January 25.
Item 26.
Petitioner is a medium industry engaged in the business of manufacturing pillars.
Have you gone through this case?
My lord, Lordship has directed me to place the modification application in the writ appeal. What my learned senior was submitting.
You have sought for modification.
Yes, ma'am. That I may be placed and that may be clarified. Probably that was the first question your Lordship has put me in the first.
There was a direction from the division bench to the state to file a petition seeking clarification. Honorable Chief Justice has directed, sitting in division, directed the state to seek a clarification. That's why this petition has been filed.
So,
if that
this clarification which has been sought for,
yes, ma'am,
by the state, what is your submission on that clarification?
Well, clarification should have been sought for on 2 fronts. One is there is no generic name of Pilaso powder which they are admitting. For that,
either you support the stand taken.
I support at the same time. I also need further in that prayer which I am placing before your lordship.
No, then you should also file another interim appeal.
Sir, that writ is before your lordship.
No, that writ prayer is
to put it to rate contract, and then there is no generic name of the philosopher powder.
You see, once a order has been passed in writ appeal, and if you want that some further direction in that or some clarification, then an interim application is to be filed in that writ appeal, not as by way of a separate IA.
Subsequent to the disposal of the writ appeal, a fresh cause of action has accrued in my favor. So that I am challenging in this next writ manner, which is before your lordship. A cause of action has accrued. That's why I have come up before your lordship. And
have you filed your objection in that?
Yes, in the writ we have filed the objection. Yes. What I humbly submit, my lord, if your lordship may kindly permit me, if this clarification IA number 578 of 21, if your lordship considers this, either or my lords, if my learned senior exit, my lords, part of the writ petition, the complications and the issues in the writ petition can be reduced, and then your lordship may take up the writ petition and can adjudicate that. That is what my humble submission is.
All right. So then let it come after Xmas holidays. Yes. Yes. Next.
Your lordship may fix a date.
Second week.
Item 27.
Your Lordships, I may be permitted to appear on behalf of Mr. R.K. Raut. Your Lordships, I'm
seeking for a short adjournment, Your Lordships. This matter will be argued by Senior Advocate Mr. S.P. Mishra.
No, it's all right. You have received the counter affidavit
Yes, Your Lordships.
and also rejoinder is ready. Right.
So,
Mr. Udgata,
Yes.
any objection to the mention is made on behalf of Mr. S.P. Mishra and Senior Advocate for adjournment. Mr. B.N. Udgata and counsel appearing for the bank has no objection to such prayer for adjournment. Put up this matter. How do you put them?
Obliged, Your Lordships.
Item 28.
Please, my lord. My lord, here in the last occasion, my lord heard this matter also sought for instruction for given an appointment for the rehabilitation assistance scheme.
No, we have stated that if anything can be done,
Yes.
it's not that because he is a
Yes.
practicing lawyer and
They have given appointment on the rehabilitation assistance scheme to other persons also. Same benefit to have
any communication
I've
has been
taken
received.
instruction, but difficulty is that because she is not coming under the scheme, compassionate appointment scheme, that's why we are not able to accommodate her. Because that scheme was also our subject matter in one, the NALCO compassionate appointment scheme. One matter in Supreme Court also matter went till Supreme Court. Supreme Court also dealt with the compassionate appointment scheme and held that only if the person is coming within the scheme, that judgment also have pleaded in the counter affidavit, that only if it is coming within the scheme, then only employment can be given. So that is the difficulty. If your lordship may permit, I will just place that judgment also. That is 2013, reported in 2013, 16 SSC 622. Last.
You have already filed your counter.
Yes, since a long time. And in the counter also, I have relied on this judgment, and the judgment also, because that NALCO scheme only, that compassionate appointment scheme was subject matter in that SLP. And Supreme Court dealt with the scheme and specifically held that only if they are coming within the scheme, then only employment can be given. And in this case, since 2011, the father of the petitioner was not in employment. And the scheme says only if he is continuing in employment, he is in employment, and during course of employment he dies, then only compassionate appointment can be given.
So why he was not there in 2011 means why?
2011 he was removed from service.
Okay.
Then he approached the National Human Rights. Then Human Rights advised us to reinstate him. We gave him an offer of employment. He did not join. From in 2011 only we offered him to come and join. In 2017 he gave a representation that I could not join. After 6 years he gave a representation, I could not join. Please take me back. Then we refused that, because since meantime 6 years has elapsed, we refused. Then he went to Central Administrative Tribunal. Tribunal, ultimately the matter was pending. During pendency before the matter of the tribunal, the petitioner's father has died. And the petitioner has also withdrawn that I am the legal heir, and since my father has died, I am withdrawing the petition. So that issue remained, was not decided. And then the petitioner approached the Central Administrative Tribunal, claiming the same prayer, compassionate appointment. That was rejected. The tribunal held that since she is not falling within the scheme, so the prayer cannot be allowed. Then in the present writ petition also, there is no prayer to challenging that judgment of the order of the tribunal. When I raised that objection in course of hearing in around in June 2000 in this year, the petitioner said that submitted before this court that they will file a petition for amendment. They filed a petition for amendment challenging the order of the tribunal. But subsequently that IA has also been withdrawn. So as on date, in the prayer also, if you lordship may see, the prayer is not, there is no challenge to the order of the tribunal. And whatever the prayer he's now made for praying for compassionate appointment, that prayer was made before the Central Administrative Tribunal and has been rejected.
Mr. Panda,
Sir.
It's if you are claiming for appointment in a central government employee post, can you directly approach this court?
No, we have approached the Central Tribunal.
Just take pause for a moment.
Sir.
So you admit that you cannot directly approach. You are to. It is to be routed through the central administration. And if you are not upheld that quorum,
Sir,
how can we directly entertain
please
this?
see this at page 29, sir. Please, page 29.
What page 29?
That is the order of the Central Tribunal.
You are
In
Mr.
fact,
Paul.
the circumstances of the present case, when
You not heard what he said.
yes, yes,
That order has not been challenged before us.
Yes.
So you are making directly prayer before us. You have already availed that Central Administrative Tribunal. Your prayer was rejected. So you should have challenged that order.
no,
this
sir.
year.
Sir, initially, page 29, sir. Please peruse the page 29.
Yes.
Para 4, para 4.
Hmm.
In facts and circumstances in the present case, when the ex-employee has been discharged from duty by order dated 16/2/2011 Annex A by 2, this tribunal finds that no illegality has been committed by the respondent's organization refusing to give compulsory payment in favor of the applicant number 2, who is also daughter of the ex-employee, since the said is not permissible as per the provision of NAFCA. However, on the issue of extending medical activity facility application, since her condition is stated to be serious and the ex-employee had given more than 20 years of service to respondent organization, we direct the respondent, the department, to consider us request sympathetically and dispose of it in accordance with the law if applicant number 1 requested for same in writing with 2 months the receipt of our request.
कौन है लाता परे?
That was the order passed by the Central Tribunal. Sir.
So आपनकर prayer कौन थिला? Central Government, Central Administrative Tribunal.
Central Tribunal.
Come to paragraph number 1.
Sir. Under these circumstances, it is most humbly prayed, therefore, that the Honorable Tribunal may graciously be pleased to direct the respondent number 1 to consider the prayer for employment of the applicant number 2, which has already been applied against a advertisement graduate engineer post 2016 to quash the annexure A by 23 order dated 10/4/2017 and provide the medical credit facility to the applicant number 1, who is also a kidney patient, and now 2 tumors are showing in the stomach now.
So এই जो prayer आपण କରିଥିଲେ Central Administrative Tribunal रे आपनको prayer टा allow ହେଲା कि?
No, that has not been.
ଏଇଟା dismiss ହେଲା?
Sir.
ତାହେଲେ ଆପଣ ଯେତେବେଳେ ଆସିଲେ ଏଇ High Court କୁ
ଆଜ୍ଞା,
ସେ order ଟାକୁ challenge କରିବାର ନଥିଲା?
Sir, we have challenged that order.
ସେ prayer
ପଢିଲେ?
Sir,
prayer ତ ପଢିନି. କୋଉଠି ଲେଖିଛନ୍ତି to set aside the order of the dated.
The petitioner above named therefore most humbly prays that this honorable court may graciously to admit this case and sympathetically towards deceased employees' family members and pass an order to consider the appointment of the deceased employee daughter, petition number 2, under the compassionate appointment or rehabilitation scheme available for the central government employee public sector rules. The direction would be deemed just and proper. Though they have specifically, he has not prayed for the set aside the that.
ଆପଣ ଯଦି ସେ prayer ନ କରିବେ challenge କରି ସେ order ଟା ରହିଲା ନା ନାହିଁ?
Sir.
If that order stands and you are not making a prayer to set aside the order,
sir,
how can we directly entertain this application for compassionate appointment?
Sir, para 10 of my petition, para 10, sir.
Prayer
nahi, apun para body
then I have to file an amendment petition only.
They filed an amendment that has they withdraw. Then they withdraw.
ଆପଣ ସେଇଆ କହୁଛନ୍ତି ଯେତେବେଳେ ସିଏ ସେଟା point out କଲେ ଆପଣ ଗୋଟେ interim application ଦେଲେ ତାକୁ include କରିବାକୁ ସେଇ prayer portion ରେ ପୁଣି କଣ ପାଇଁ withdraw କରିନେଲେ?
Only liberty to file an amendment.
କଣ ଆପଣ file କରିବେ ପାଇଁ we are adjourning the matter, whatever you want to do, do.
Sir.
The Mr. Panda, Land Counsel for the petitioner, submits that he intends to file an interim application seeking amendment to the prayer portion of the writ petition. Case is adjourned. Give it a yes.
Published.
Item 29.
Item
29, Lordship. Perhaps you have not come with instruction that. But Lordship, kindly see the noting is there. Self-same writ application considering the self-same prayer. Lordship rejected, Lordship, kindly see. So, both the writ application in this case, it can be disputed in that light, Lordship.
Just a minute, sir. Item number 29, which is for the petitioner?
Lordship,
state is the petitioner.
State is the petitioner.
Oh, 19 similar writ petitions have already been. That's
is it a correct
we did our Because only two similar cases we could find, my lords. One is there in your lordship's board. Another writ petition which we could get, my lords, WPC number 8140 of 2022, which is not there, my lords. So, my lords,
The question is that if similar matter
yes, my lords.
has been adjudicated by the
Yes,
by
ma'am.
this court,
Yes,
and that is against you,
yes, my lords.
and you have not challenged it before the Honorable Supreme
My lords,
Court,
my lords.
then if the same ratio
Yes,
is applicable, factual aspect, it is also applicable to the present
Present
case,
case, my lords.
then similar order
Yes,
should
my
be
lords.
filed.
Considering
Otherwise,
this,
you could have sought for review,
yes,
could have challenged in the Supreme Court. You
my
have
lords.
not done if that, then
My lords, we have done our due diligence, my lord. Your lordship is absolutely correct, my lord. Also directed to collect all these numbers so that all this can be disposed of.
you want some further time.
Yes, only two
Or
cases we could
the
find.
learning council
But
could
lordship,
say
the judgment relied upon that case that has been gone up to Supreme Court, that has been dismissed.
the learning
हाँ, तो
council
कौन
could
कहीं
say
का कहीं
some
होता है?
further time
That
to find out the other writ petitions pending before this court, public disposed of by this court on the similar point. Hello? Court of this matter, that I would see, third week of January 2025. Hello? Yes.
Lordship, other cases disposed of ହେଇନି sir, ଏଇ similar pending ଅଛି.
ମୁଁ ଆମେ ଲେଖିଲୁ ତାକୁ ସ୍ଲାସ୍ କରିଦେଇ ଲେଖିଲୁ pending or disposed of.
The next
Disposed
day
ଆସିଯାଇଛି ଆପଣଙ୍କ list ରେ ଆସିଯାଇଛି.
ଜାଣି ସେ କହୁଛନ୍ତି ଆମେ ସବୁ କେସ୍ ର ଡାଟା କଲେକ୍ଟ କରିନୁ, ଆମକୁ ଟିକେ ଆଉ ଟିକେ ସମୟ ଦିଆଯାଉ, ଆଉ କେତେ କେସ୍ ପେଣ୍ଡିଂ ଅଛି ବା ଆଉ କେତେ କେସ୍ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି ତାର କମ୍ପ୍ଲିଟ ଡାଟାଟା ଦବୁ, ସେଇଥିପାଇଁ ଆମେ ରଖିଛୁ।
Lordship, next week ଆସିଛି.
Next.
Item 30.
This matter relates to compulsory retirement, wherein the petitioner has been compulsorily retired, taking into his past services after his promotion.
Yes, Mr. Behra was to
Yes,
argue.
I just recollecting.
Mr. Behra, you have all the documents of the review committee. Have you
No,
got it?
only one document has been
Why?
filed in the counter, my lords.
Why? You could have
That was
got
the
it.
difficulty in the last, my lords.
No, why difficulty? You could have asked your client.
My lords, we have written letters, my lords. That review
Because
committee.
it is based on the review.
Yes, my lords. Yes, my lords.
Committee.
Plus the allegations and the points which has been considered by the honorable review committee has been averred in the counter.
Yes,
but my lords, that has
you
not
could
been
have asked
annexed.
the documents from the Registrar of Vigilance or through the court.
My lords, that we have asked for, my lords, but in the counter it has not been filed.
Or else how can you argue it?
My lords, only
Because
on the,
he has a very
yes,
clear case
yes,
that although the averments have been made, there is
yes,
no document.
yes,
So unless you have it and place it before this
my
court
lords,
for perusal,
my lords,
because the court has taken the entire record of the
yes,
incumbent officer.
yes,
so that has to be there.
Well, it's one part is that document is not filed, well, it's only averments are filed. Well, it's, so that is why
No,
I have
certain
asked.
documents cannot be filed because it is a
That is exactly what has been pointed out. Suppose
Yes.
you don't want to disclose these documents in your counter
My
affidavit, but
lords.
for all the same, you have to produce it. It must be ready with those documents. We are
My
not
lords.
telling that it is to be produced in sealed cover or something. But if we suppose he doubts,
My
he
lords.
says challenges that
My
no,
lords.
this government is not correct. We can ourselves, for our satisfaction, peruse it.
My lords, for your lordship's kind perusal, I'll produce it.
yes, only for that purpose.
How can the matter be finally adjudicated?
It already he has been
He has already.
Well, considering this, I found few of the judgments that mere allegation in such cases, I mean, subject to your lordship, may I permit to submit. Last occasion, your lordship has pointed out, I have tried to send letters to get those documents for your lordship's kind perusal. Because it could not be produced, my lords, I'll produce in the next date. But my lords, I found few judgments where, my lords, mere allegations have also been taken seriously.
yes,
and-
yes, that is there. That is that
On merit,
part is
my lord.
on.
Lordship has directed me to get
But,
prepared in both ways.
See,
so-
there are two things. If there are documents, that
Yes.
is one part.
Yes, my lord.
and there are some allegations which can also be taken into account by the review committee is another.
Yes, my lord. So the second part, I'm prepared to, I'll submit the document.
If at all you have any document to substantiate the contentions made in the counter affidavit,
My lords.
why don't you have it in the sealed cover so that we can place?
I'll produce it. I'll produce it.
My lord,
He has taken the matter thrice.
Yes, yes,
my lord, another the Lord Counsel for the state may take instruction particularly on the issue. Your lords, can have at page 174.
What is that?
The compulsory, my humble submission is that, and the rule says that the compulsory treatment is a simplicity. There is no punishment. But here in the
mere a statement has been written in the counter, a punishment doesn't amount to punishment. No. You cannot take it beyond rule, no?
Let them take instruction.
No need on that. That is an averment made.
That is the previous punishment or previous return has been rightly passed by the review committee. This is the.
Even if he writes, that is not the contention. You have to say what is there in the rule. Even if he says that this is punishment, can it be taken as punishment? No. It is to be said.
This is not
My
punishment.
entire endeavor is to.
No. Is it this only statement made by this count in the counter, or it is the consistent case of everywhere that this is a punishment? Do you have any contention that this is a punishment according to you? In any, then how can
I do not know.
So, but merely because he writes in a particular sentence that this is punishment amounts to punishment.
But I have only cited 3 judgments of the Honorable Supreme Court
showing that this is punishment.
So showing that no, that the past events cannot be taken into account.
That part we'll see. That you have already argued.
Already argued beyond
that you have already taken note of.
The Learning Council for the state submits that the counter affidavit, averments taken in the counter affidavit is based on some documents, but he is not having those documents at present, and some time may be granted to produce the documents. Put up this matter. Secondly, January.
As last chance you don't.
Yes, yes. Last times, otherwise taking.
The land it makes clear that no further adjournment shall be granted. Yes.
Obliged.
Item 31.
Actually, Mr. Behra, your name is.
I cannot.
So, who is to argue? Where is Mr.
My learned DSJ.
Mr. P.K. Padi, where is Mr. Padi?
Mr.
Padi.
Yes, ma'am.
Mr. Prabhu Prasanna Behra now ଅଛି Central Government Council. See to state.
I will take care of my lord. Let's make it after vacation.
ଆପଣଙ୍କ ସେପଟରୁ ଏପଟୁ କେତେ ଆସିଲା ଆଉ ଏପଟୁ ସେପଟୁ କେଇଟା ଯାଇଛନ୍ତି?
ଏଠୁ ସେପଟୁ ଆସିନାହାନ୍ତି, ଏପଟୁ 26 ଯାଇଛି 26.
Learning Council for the Mr. Padi Deputy Solicitor General that some other central government council will be engaged in this case as Mr. Prasanna Behra is now in the state panel of the Article General. Yes.
Huh? Item 32.
Item 32. Before my learned senior starts, item 32, the records are missing. I don't have the record from the state.
Last time it was there. You took time for some other. Just a minute. The last order was passed on 25/11/2024, and we have noted down that Mr. Patnaik filed citations after serving copies on the Learning Council for the state. So, written note of submission has also been filed, date chart has been filed, memo of citations have been filed. So, you are not having the record.
Probably it would have been assigned to some other law officer. That's why. So that is the difficult one.
Last time Ravinder Mahanti ko na lekha ithila. Seteବେଳେ ତ କିଛି କହିନଥିଲେ. Record thila. Record thila, so I am not prepared. The କାଲି का record नहीं है. अन्य matters will play that will be difficult. Like second week of January 2022. Yes.